Although the threat seems to have been stated, whether or not it influenced you, to your understanding under U.S. law, and I realize we're not asking a banker to be a lawyer, but does the Federal Reserve Chairman have the right to fire you or any member of your board?
I think there's something called a cease and desist, which gives them power to do things like that. But I've been told that. I haven't read it myself.
Okay, and the U.S. Treasury Secretary, any similar power?
No, sir. I don't think he would have the power.
Okay, but when acting in concert, you would perceive that threat to be real, that he could execute on that threat of having you and or your board relieved.
But my perception was that he was speaking on behalf of himself and the regulators. And my perception was in concert they would have that power.
Thank you.
Thank you very much. I now yield to the gentleman from Pennsylvania who's been working on these issues for more than 20 years, Congressman Kanjorski.
Thank you very much, Mr. Chairman. Mr. McHenry made a comment in his introduction to you that Bank of America has business relations with 98% of the Fortune 500 companies. And what I want to know is, what are the 10 companies that aren't doing business?
I don't know, but it's a very interesting question.
Get home and check that. Right? Mr. Lewis, in some regard, we have important questions here that we're trying to resolve with reforming regulatory authority in the United States. So to that extent, these hearings are helpful. But I don't hear anything thus far, either by my colleagues or yourself in responding, that there was some perceived threat or abusive action on the part of federal regulators. So I'm going to ask you directly, do you think Mr. Bernanke or anyone working under the Federal Reserve Chairman took unauthorized, illegal, or improper action toward you or the Bank of America during these trying times?
I do not. I would say they strongly advised and they spoke in strong terms, but I thought it was with good intention.
If I had to characterize it, I was thinking that if the Titanic were going down and some of us were in the life rafts, it sounds like an argument between the captain and someone that's in the water and they're refusing to get on board and he's ordering them to get on board. Is that not too dissimilar to what happened here on this mid-September to December period of time when all of us admittedly had our hair on fire?
Yeah, and I think they saw, probably with their perspective, they saw rougher seas ahead that no one institution would be able to see.
Right. The one thing, because my subcommittee on financial services is charged with looking at the reform of regulation, is there anything that you could see that in, granted, extreme circumstances, such as that weekend of September 15th and the failure of Lehman Brothers and what was happening in the implosion or collapse of the financial system, is there anything that we could do in reforming the regulations to provide for faster disclosure? For instance, the 8K requirements that were not carried out precisely in this case, and that disclosures by the company were not necessarily made within the 4 days. I know there's an argument as to whether or not they legally had to or were defined as required. But is there something we could do to assure shareholders who do get at risk as a result of not forced but encouraged acquisitions such as this? Is there anything we in the federal government can do to clarify that problem and to make it clear that would help the banking institutions in future events of this sort?
Sir, are you speaking to the Lehman or to the Merrill Lynch?
No, to the requirement of your filing for disclosure and notice to your shareholders when all of this was pending. You didn't necessarily precisely follow what could be considered a notice requirement.
I think clarity is always better. That's where I would. That was if it were left up to me, I would go to clarity first.
So, what would you recommend that we do? Go into that area and declare more disclosure as to what's happening or how it's happening, or will we Shall we put you on the net or what?
No, I don't know. I'm not sure I'm following you in terms of the disclosure that you're speaking to. So I'm a little shaky on your question, frankly.
Okay. Well, do you know of any disclosure? Do you have any feelings of any disclosures that could be made at those, highly charged, extreme circumstances that you were operating under? Is there anything that we could create in the reform of our regulatory requirements on acquisitions or mergers?
It's hard. It would be difficult because you don't have an event many times because you're still looking at alternatives and negotiating and Lehman or the Merrill Lynch Bank of America situation, and then it could be well into the morning before you actually get a signed deal, and then you do announce it the next day, for instance. And so the ebb and flow of the circumstances would make it very difficult to describe it as an event because it just may not happen that way.
Now, I understood in your testimony you pointed out that Merrill Lynch acquisition was responsible for 75% of your last quarter's profits. Are you aware of shareholders that are complaining about that acquisition as a result of that?
No, sir. Not now.
Okay, thank you very much. I yield back.
Right. Thank you very much. I now yield to Mr. Chaffetz, the gentleman from Utah. For 5 minutes.